Testimony about materials found on Mr. Glover's cell phone constituted a plainly erroneous violation of Mr. Glover's right to confront witnesses against him under the Sixth Amendment and Article 1, Section 9. My basic argument is that the extraction report created by FBI agent Rich Campbell was testimonial under the Tennessee Supreme Court's 2016 opinion in State v. Hutchison because it was created to prove past events potentially relevant to a criminal prosecution and because it was made to accuse a targeted individual.
So are you here on plain error review on this one?
This issue was not raised by defense counsel at trial. We're not entitled to plenary review.
So your friend on the other side cites the treatment by the Supreme Court in Dotson to say basically the law is so unsettled in this area from the United States Supreme Court that there is not a clear and unequivocal rule of law. And so that raising plain error in this context, you can't even really get over that first hurdle. So what do you say?
I would say that that argument would be valid.
That's what Dotson said, it seems.
That is what Dotson said in 2014.
Right.
However, in 2016, 2 years after Dotson and 2 years before the events at issue in this case, the Supreme Court issued its opinion in Hutchison, which clarified the law pertaining to the admission of forensic reports when the author of the report does not testify at trial.
Okay. So what is the clear and unequivocal rule of law you believe has been breached?
The rule that is established in Hutchison interpreting the U.S. Supreme Court's precedents in Melendez-Diaz v. Massachusetts, Bullcoming v. New Mexico, and Williams v. Illinois is that when a court is reviewing the admission of a forensic report, absent testimony from the author, and trying to determine whether or not it implicates a defendant's confrontation clause rights, it has to look at the threshold issue of whether or not the report is being prepared for the purpose of a possible criminal prosecution. If you clear that threshold, then you're looking at whether one of two different other issues is present, other factors is present. Either whether or not there is a sufficient indicia of solemnity, as discussed in Justice Thomas's concurring opinion in Williams v. Illinois, or whether or not the report is written for the primary purpose of targeting a particular individual, which was the analysis in Justice Alito's plurality opinion from that case. So the state in its brief points out that Williams is a plurality opinion, there was no majority, and so it doesn't provide clear guidance for trial courts in determining whether or not a report is admissible without testimony from the author. But the problem is solved by the Tennessee Supreme Court in the Hutchison case. It basically solves the problem by synthesizing those two opinions and creating, I think, very clear analysis for a trial court to apply in these situations.
Let me ask you this, if I could. So Hutchison, of course, involved an autopsy report from a forensic pathologist. These other confrontation cases that we've seen down through the years involve DNA analysis. Here we're talking about a cell bride extraction. So I'd like to know initially, what does this record reflect? I know probably everyone here knows what a cell bride is. What does this record reflect a cell bride extraction is and what it entails?
So, and this goes to the first of the Atkinson factors. What the record establishes, primarily through the testimony of Detective Chad Gish from the Metro Nashville Police Department, is that Agent Campbell performed an extraction using the Cellebrite, however you pronounce it, software. Detective Gish describes it as a forensic platform, one of three major software packages used by law enforcement to analyze cell phones. He describes this extremely high volume of data that is included in the report, which I'm not sure that I think he hints at this, but doesn't explicitly state it. The report is in electronic form. It's not typically printed on paper. If it was, it would take maybe a few 100,000 pages.
How does that report happen, though? Where does it come from?
The reports are generated, I think, by running a cell phone through the software. Detective Gish, I don't believe...
So you plug it in?
I
And
don't
it-
think that this is clearly stated in Detective Gish's testimony, but yes, just being a criminal defense lawyer, you plug a phone into a computer and run the software. I'm not sure what else is entailed or what sorts of decisions the analyst has to make when preparing the report. But that's my
And that's
understanding of
not
the basic
reflected-
mechanics of it.
Okay, and that's not reflected in this record. If there are additional steps or procedures that this person takes.
No, I mean, Detective Gish testifies about the fact that he's done at least 1,000 of these extractions and that he has received extensive training in how to perform them and how to analyze the results. Most of his testimony is concerned with the specific pieces of evidence and data that are found on the phone as reflected in the extraction report. He talks about Facebook communications that are found between Mr. Glover and his co-defendant, Mr. Jones. He talks about cell phone communications between the phone and co-defendant Orlando Harris. He talks about an Instagram photo of Mr. Glover and Mr. Jones posing in front of a car that appears to be the Nissan Maxima that may have been involved in the robbery kidnapping, and also testifies and is used to admit and authenticate a photo of Mr. Glover posing with a gun pointing it at the camera, the same photo that's at issue in issue 2 of my brief.
Yeah, but getting back to the report itself, because that's really the missing link in confrontation that you're bringing to this court, as I
Yes.
understand it. Is there a distinction there between, on one hand, plugging a cell phone into a piece of software and letting the software generate a report that some other expert takes and analyzes, versus a forensic pathologist conducting an autopsy, analyzing tissue, cutting open a body and making findings about that body and putting those into a report, or a DNA serologist analyzing DNA and making comparisons and coming to conclusions and putting that into a report? Aren't we talking about something a little bit different here when we're saying a Cellbrite report?
I think a Cellbrite report is definitely different from an autopsy report. A machine is used to generate the report, and this was an issue that came up in both the Melendez-Diaz and Bullcoming cases. Those were both cases that involved either gas chromatography or mass spectrometry tests of drugs and blood sample, respectively. And in both cases, the prosecution argued that those reports, those certificates of analysis, did not implicate the confrontation clause. They weren't testimonial because they were machine generated. And the U.S. Supreme Court rejected those arguments in both cases. The fact that a machine was involved in generating the data that is reflected in the report did not take it outside of the orbit of the confrontation clause. I think it's the same situation here. Ultimately, this report is a set of statements about the exact data and evidence that is contained on the phone. And so it's a statement within the meaning of Rule 801A. It is a written assertion.
But even in those cases, you're talking about taking a powder substance and assigning a scientific identification to that. They're saying, yes, this is cocaine. And there must be an expert that can describe how that occurs. Or with blood alcohol, you're taking breath or blood, and from that you're assigning a BAC number.
Mm-hmm.
Someone has to explain how that occurs. In this instance, it almost seems like you have a box of data and you're handing it to one person. He's opening up the box and handing it back to the testifying expert. And it's the testifying expert that's reaching into the box, pulling out the data and saying, this is what this means.
Well, the testifying expert in this case is testifying about data that is extracted and prepared by a separate expert. Detective Gish testified extensively about all the training that he has had to complete in order to do this line of work. He is qualified as an expert in forensic data analysis, and that's the norm in situations where where the state is trying to admit a forensic extraction like this. And so I would just go back to the analogy with Melendez-Diaz and Bullcoming. Just the fact that a machine is involved in this does not mean that the contents of the report are not statements implicating the confrontation clause or the hearsay rule. One of the issues that the court may have is reliability. The idea that if you are extracting data using this machine, it's sort of incontrovertible that this information was in fact on the phone and that there's nothing much to cross-examine an expert about. And I think it's just worth, if I could briefly quote some language from the Crawford opinion that is then replicated in Melendez-Diaz. Justice Scalia wrote, "To be sure, the clause's ultimate goal is to ensure reliability of evidence, but it is a procedural rather than a substantive guarantee. It commands not that evidence be reliable, but that reliability be assessed in a particular manner by testing in the crucible of cross-examination. Dispensing with confrontation because testimony is obviously reliable is akin to dispensing with jury trial because a defendant is obviously guilty." And so I think the fact that, that it definitely would appear based on the extraction report that this material was in fact on Mr. Glover's phone is sort of beside the point. That because these are statements that are being made by a non-testifying expert witness for the purpose of targeting a specific individual, they implicate the confrontation clause. And it's very different from, I would say, the cell mark report, the DNA profile at issue in Williams, and also from the autopsy reports at issue in Dotson and in Hutchison, in that, this is clearly targeting a specific individual. It's sort of self-explanatory. They're taking this particular suspect's phone and extracting it. There's no question that they're doing that with the hope that they may find evidence that this particular individual committed the crime. So that's the main point of distinction between this and in those cases. In terms of the other Adkisson factors, I think that the record clearly establishes what occurred in the trial court. Regarding the second factor, whether or not a clear and unequivocal rule of law was breached. To my knowledge, there are no precedents of this court or the Tennessee Supreme Court that specifically address whether or not a cell phone extraction report can be testimonial for confrontation clause purposes. But I think that is not the issue. The issue is whether or not the rule of law is clear. And my position is that since the Supreme Court decided Hutchison, the law has been clear, even if it hasn't been applied to this particular fact pattern. In terms of...
And so, what you're saying there, let me just see if I can repeat the argument so that I understand the argument. The argument, I think, is that the precedent may be unclear from the United States Supreme Court. The precedent is not unclear from the Tennessee Supreme Court, because the Tennessee Supreme Court has essentially taken all of these various different tests that have been applied and put them into one single test.
Yes.
Right?
Yes. They've created a situation where
you have to satisfy all of the plurality opinions.
Yes.
And if you get through that thicket, then you've got an issue.
Yes,
okay.
Exactly. Yeah. So I think that for example, the drug certificates of analysis at issue in Melendez-Diaz and the blood alcohol content analysis from Bullcoming, those would be both testimonial under Hutchison because they contain sufficient indicia of solemnity. They're basically affidavits. They're notarized documents that are the functional equivalent of affidavits.
And that factor is not relevant here.
That factor is not relevant here.
But the next one is, you said.
The additional factor that's present is the fact that the statement is being made to target a particular accused individual. So it's the Alito concurrence.
Sure. Okay.
In terms of the third Atkinson factor, a substantial right of Mr. Glover's was adversely affected. Crawford is very clear that the confrontation clause is a bedrock procedural guarantee. I think any of the rights enumerated in the Sixth Amendment are going to be substantial rights. Mr. Glover did not waive this issue for tactical reasons. There is nothing in the record supporting that argument. I don't believe the state makes that argument in their brief. And consideration of this error is necessary to do substantial justice. The evidence that Detective Gish testified about was very significant for the state's case, and it was all of those four pieces of evidence were all emphasized by the state in their closing argument. And so my position is that the erroneous introduction of this evidence entitles Mr. Glover to the reversal of his convictions and for these charges to be remanded for a new trial.
Was any of that proof that came from the Cellbrot report also present in other proof presented?
So there was a photograph of Mr. Glover and Mr. Jones on the car that I believe was also found by the lead detective, Detective Cuthbertson, on Mr. Glover's Facebook page. In terms of the communications on Facebook between Mr. Glover and Mr. Jones and the cell phone communications between Mr. Glover and Mr. Harris, I think that the phone was the sole basis for that. There were other pieces of evidence suggesting a link between those individuals. There were the traffic stop reports that were testified about where Mr. Glover and Mr. Harris were both in the car, I think in July and August of 2018 before the offense date here. But the phone was the sole source of the photograph of Mr. Glover with the gun. Yes. Thank you very much.
Thank you.
Good afternoon. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, we are here under plain error on this issue, and defense counsel is arguing that Hutchison is now a clear and unequivocal rule of law on our United States Supreme Court plurality opinions. Hutchison was where the defendant raised the issue at trial. He raised it in his motion for new trial, so it was properly before the court under plenary review. But you called it a thicket. I call it threading the needle on all the plurality opinions, but it's exactly the same thing. And the one part that defense counsel cannot thread the needle on is Justice Thomas's plurality opinion on the indicia of reliability. He wanted affidavits or depositions at the conclusion of any document that's purported to be testimonial, and we don't have that in this case. We just have, it's not in the record, but it's a cell phone data dump. All we have is in the record is just copies of pages that were presented from the Celebrate report that just say phone number, what the name of the contact is in that person's phone. So if we're going to rely on Hutchison, which I think we're still in Dotson, which is saying it's waived and you cannot show a clear and unequivocal rule of law. But if you want to say that we are under Hutchison, it fails because he cannot meet the Justice Thomas plurality opinion on indicia of reliability.
Is that, so what is the test in Hutchison? I know you have the primary threshold question to determine whether the report is testimonial. So you consider whether the primary purpose was to prove past events. Mm-hmm. And then I think once you reach that threshold, isn't it an either or proposition that you can either prove Justice Thomas's indicia of solemnity prong or Justice Alito's targeted individual prong? You have to prove both of them?
The way I read Hutchison, I thought you had to do both.
But I thought our cases had them in the alternative. Is that if
Pardon
you
me?
I said I thought our cases though had them in the alternative, as Judge Hickson is saying. That if you satisfied one, okay, you didn't have to satisfy both.
I understood it to be that you had to do both. But even if you have to do alternative, we're still under plain error review, and going down from clear and unequivocal rule of law, we do not need to do plain error review to do substantial justice. Because if you just take out all of the evidence from the cell phone, you have the victim positively identifying the defendant as the person who perpetrated all these crimes against him. He gave 100% as his power of observation. He said, I'm 100% certain that this is the person who did this to me. And the jury can accredit that, and they did accredit that. So even taking out the cell phone celebrate, it's not necessary to do substantial justice to reverse on plain error review. If there are no further questions, I'll rely on my brief for the remainder of the issues, and we ask that you affirm.
Well, I guess before you sit down,
Sure.
I know you have a little time here left. Make you earn your keep today.
I was trying to get away.
So the defendant argues under the necessary to do substantial justice prong that this cell phone evidence was central to the case because the Facebook evidence showed frequent communications between Glover and Jones. Call log showed repeated calls between Glover and Harris, who was the driver. And the state emphasized in its closing argument how unlikely it would be for the victim to identify three people in lineups who actually knew each other. Particularly that last part, when I read that, doesn't that seem like pretty compelling evidence when you're arguing for the jury to accept and give weight to the identifications provided by the victim?
I think it's important, and I see why the state emphasized it in its closing argument because of the high burden they have beyond a reasonable doubt. But is it necessary to do plain error review for substantial justice? No. Our answer is no. And I understand your question. But again, if you take that out, you have the victim identifying all three co-defendants without hesitation, 100% certain of his identification of each of the three defendants. We have officers who have found this defendant Glover, in the car, that car that the victim identified, because it was very unique. It was spray painted black and had a weird bubbled surface on the dashboard, and that exactly matches the defendant's car. So we have testimony outside of the phone calls linking the three co-defendants together. It was not just the Cellbrite that tied them together. We have them caught together in that car on at least 3 occasions, and the defendant was in that car on, I think, all 3 occasions, and Mr. Harris was in there on at least 2. Thank you for your time.
Thank you.
I could just respond briefly to a couple of points made by the state. It is true that in Hutchison, the confrontation issue regarding the autopsy report was subject to plenary review. But I don't think that's the issue. I mean, in the Dotson case, the Supreme Court focused on the unsettled nature of the Supreme Court's decisions on the admissibility of forensic reports when addressing the second Atkinson factor, whether or not a clear rule of law was breached. The significance of Hutchison is that it establishes the clear rule of law. So the fact that that case involved plenary as opposed to plain error review, from my perspective, is irrelevant. The only issue is whether or not it kind of clarified and settled the law on this issue. And I think that the state could make an argument that the law, that the Sixth Amendment issue remains unsettled. But the Article 1, Section 9 issue, I think, is completely clear now after Hutchison. You know, our state constitution, equivalent to the Confrontation Clause, the analysis is completely clear and settled. Just to be clear, Hutchison does not require that both of those different factors be present, that both the Thomas and Alito factors be present. It's either or.
Because you'd be lacking on the solemnity.
Yeah, I mean, this isn't an affidavit. This is definitely, in that respect, this is very different from Melendez-Diaz or Bullcoming. But, I mean, if you cross that threshold, if you're able to establish that the statement or the report is made for the purpose of a criminal prosecution, then all you need is one of those 2 factors.
Yes, I mean, that point is made clear in our cases, if not in the Supreme Court's cases, right?
Yes. I mean, it's made clear in Hutchison. Yeah. I don't know if there are additional Court of Criminal Appeals decisions dealing with it, but
yeah, okay.
But yeah. And regarding the 5th factor, the state is arguing that the 5th factor will never weigh in favor of reversal in a situation where the remaining evidence is legally sufficient to sustain a conviction. And I am not personally aware of any authorities from this court or from the state Supreme Court that hold that so long as the evidence that is not contested is legally sufficient, then a defendant can never be entitled to reversal. I mean, that's definitely, I don't think that's the standard when the court is doing harmless error analysis, and I don't believe that that's the standard that applies here. Here, the evidence that came in from the cell phone extraction was, I think, extremely important to the state's case. It was not the only proof that they had, obviously, but all of these pieces of evidence were emphasized extensively by the state. I believe it was in General King's rebuttal closing argument. She spent a lot of time talking about how unlikely it would be that Mr. Oliver would separately identify 3 different people who happened to know each other. And a lot of the proof of the depth of their relationships, how much communication they'd had, was in Mr. Glover's phone. And the state also placed a lot of emphasis on the fact that there was a photograph showing Mr. Glover with a black semi-automatic handgun that kind of generally matched the description that Mr. Oliver gave of the gun that Mr. Glover used at the time of the offense. So I think given how significant those pieces of evidence were for the state's case, as reflected in their closing argument, I think that you do have to, if you find that the other Atkinson factors are met, have to conclude that that giving him plain error relief is necessary to achieve substantial justice in this case. Thank you.
Thank you, counsel.
Thank you.
Anything further? Anything further?
No, Your Honor, that's it.
We will stand adjourned.
All rise. This court stands adjourned.